Good afternoon and welcome to this new webinar of the ASA and SCAI webinar series. This webinar series aims at giving hands-on practical tips to private practitioners, in-house counsel, arbitrators, mediators, experts. In general, it is not aimed at raising theoretical and academical disputes, but just to give practical tips to users. Today we have 80 participants registered, and most of them in-house and private practitioners. We are going to talk about how to select arbitrators and mediators and also experts as a counsel, but also as a co-arbitrator and also as an institution. How do institutions appoint arbitrators and mediators, or sometimes also experts? I will present Bernd, who is our head speaker today, a little later, but I would like to as well let you know that this webinar is recorded and will be presented on YouTube and on our website, maybe today or in a few days. And I would like also you to know that on the 11th of February, we will have our next webinar that will talk about joinders of parties. This topic has been selected because the Swiss rules of international arbitration are the rules that govern the Wismut court this year. And the students are keen on hearing how arbitrators and practitioners apply the Swiss rules, and in particular, the article about joinders, because that's part of their case. And this webinar will be followed by another webinar, also aimed, but not only for the students and coaches and arbitrators of the Wismut. On the 18th of February, we will have a presentation of the life science and pharma industry, because this is the industry that is used for the case for the Wismut this year. The dispute being about a vaccine against some very nasty virus. You may guess why and what. This is also one of the main industries in Switzerland, and we thought this would be appropriate this year for the case. The Swiss rules of mediation will also be used for a Wismut on mediation that will take place in June or July, also in Vienna, and live on per webinar and online as video conferences. So this year is really the year of the Swiss rules, whether that is of arbitration or of mediation, and it's also the year of the Swiss Chambers Arbitration Institution and of the ASA, who are more or less merging without completely merging, but at least enhancing a lot their partnership for the good of all the arbitration community, and in particular of the parties and companies using their services. This being said, I would like to introduce Bernd Ehle. Bernd Ehle is a partner at LALIVE in Geneva. He's acting both as counsel and arbitrator. He also represents parties in arbitration related setting aside proceedings before the Swiss Supreme Court. Bernd is a former co-chair of the Geneva group of ASA, and today is a member of the arbitration court of SCAI. So a pure Swiss product imported a few years ago for the pleasure of most of us. Bernd, the mic is yours.
Thank you very much, Caroline. I have the pleasure of introducing the two other speakers. So we have Maria Hauser-Morel, who is based in the Paris office of HANEFELD, an international dispute resolution boutique firm. She acts as counsel and arbitrator, and prior to joining HANEFELD, Maria was counsel at the ICC Court's Secretariat in charge of the Central and Eastern European team. And Pierre Muller has worked as a judge for 20 years and now devotes himself entirely to extrajudicial dispute resolution as arbitrator, conciliator, and mediator, and by setting up tailor-made resolution processes. Let's move on and look at our slides. Maria, if you could please share the slides. So we are going to discuss how to select arbitrators and mediators. We can move on to the second slide, please.
Sorry. Up. I'm so sorry. Up. There we go. Ah, no, the view is not good. Up.
There we go. That's better. Thank you. So the topics we're going to cover in this webinar are as follows. First, a quick reminder of the importance of the selection of arbitrators and mediators as a procedural step. Then the core of the presentation is about the actual selection of arbitrators and mediators. And at the end, we'll say a few words about the revised rules of SCAI as appointing authority and case administrator. And there will also be time for questions and answers. And as Caroline said, we'll focus on practical questions and tips. The next slide, please. So turning to the significance of the selection, the freedom to select arbitrators and mediators emanates from the parties' freedom of contract. And that freedom is the main advantage of arbitration and mediation, or one of the main advantages. And it's also a key strategic decision, maybe even the most important decision that a party can take in a dispute. And as a client, if you're at the client's end, you want to be involved in this process and not leave the decision altogether to counsel. It is often said that arbitration is only as good as the arbitrators, and the same is valid for mediation. Mediation is only as good as the mediator. So this slide is to remind everyone that this is a very important decision that should not be taken lightly. Obviously, there are limits to the parties' freedom to select arbitrators or mediators, such as the independence and impartiality of arbitrators and mediators. And there might be other factors that one has to take into consideration that restrict or limit this freedom, and they may be included in the arbitration agreement or in the arbitration rules, so it's always important to take a look at these. And if there's no agreed mechanism, the parties may have to resort to the default mechanism in the lex arbitri, so in the international arbitration law, if there's any such mechanism. Now, let's look more closely at the selection of arbitrators. We'll talk about mediators a little bit later, and we'll cover the questions that you see on this slide. And we'll start with the first question, which is who makes a nomination? And I will hand over to Pierre for this. Thank you.
So thank you very much. So as we know, arbitration is a dispute resolution process that is based on the will of the parties, and their will is expressed in the arbitration agreement, which is the cornerstone of arbitration proceedings. So therefore, it is not surprising that it is although in the arbitration agreement that the answer to the question of who makes a nomination of the arbitral tribunal has to be sought. So there may be several practical situations depending on whether the parties have agreed on the number of arbitrator, 1 or 3 in most of the case, and on the application of the rule of an arbitral institution. So now if we have a quick look on the main situation we find in practice, starting with the case where the parties have agreed that the arbitral tribunal will be composed by a sole arbitrator, in that situation, the party will try to agree on the person who will undertake this role, and in case they fail to reach such an agreement, they will turn to the to the institution or another appointing authority that is competent according to their arbitration agreement. In case there is no such institution or authority that is vested by the parties of the power to do so, then subsidiarily the party can ask the state court judge, what we call in French the juge d'appui, to select the sole arbitrator. A second situation, in case the parties have agreed on a 3-members arbitral tribunal, then each party will appoint one arbitrator, what we call co-arbitrator, and both co-arbitrators will then select the presidents. And once again, if there is a difficulty, for example, one party does not appoint an arbitrator or the co-arbitrators are unable to agree on the person of the president, then the nomination can be made by the competent arbitral institution or other appointing authority, or subsidiarily by the state court judge. It is therefore important to always check the arbitration agreement and the arbitration rules, as well as the arbitration legal framework, as shown on this slide. And now if we go to the next slide, it is also very important to check the arbitration agreement to have relevant information regarding the nomination process. And as you've seen from the two examples I gave, arbitral institution can play a very important role in ensuring the quality and effectiveness of the arbitration proceeding by appointing the arbitrator when there is a difficulty. This is also the case when the parties have not decided the number of arbitrators. And here we find the same process. The arbitral institution will decide on that question in accordance of its own rule and after consulting with the parties, or if there is no such institution vested of that power, then the juge d'appui is going to make that decision. So Bernd, you can follow up from that point, I guess. Or Maria.
No, I think it's on me. I just wanted to make sure that I can't put on my view, but that's okay. There it is. And so once regardless of who is making the appointment and who is being appointed, co-arbitrator, sole arbitrator, or president, there are some basic selection criteria that we always will have to consider. And the first one will be independence and impartiality of the arbitrator. The importance of this is for enforceability of the award. If a party takes the risk of nominating an arbitrator who's not independent, has some links to the party, for instance, this is a clear risk for the enforceability of the award that would be applied more or less all over the world. So the first clear criteria for everybody is independence and impartiality. Availability is something that we have been discussing in the arbitration world for some time now, because there have been complaints from some users about delays that occur in arbitration. These delays are not always due to arbitrators, but an emphasis has to be put on their availability as well prior to the appointment. Another basic criteria, it would appear, is the proficiency in the language of the proceedings. It seems easy like this if language is English, German, or French. It may get a little bit more complicated if the language is, for instance, Romanian. But, for instance, if you're looking for a president, there's an objection to appointing a Romanian national as the president. And then it's quite tricky to find Romanian speakers who are not Romanian and are actually qualified to act as arbitrators. Nationality is a criterion that will depend on who you're nominating. So if a party in a commercial arbitration nominates a co-arbitrator, it may be a co-arbitrator who is the same nationality as the party. But usually for appointments of sole arbitrators and presidents, the parties expect a more neutral nationality. There are also some criteria that are more relevant, related to the qualifications of the candidates. And here the parties will consider issues such as familiarity with a particular industry, familiarity with the applicable law, at least the family of the applicable law, such as civil law, commercial understanding, but also if, for instance, you're looking for a sole arbitrator or president, a solid experience as arbitrator or even experience as presiding arbitrator will be relevant. And finally, the reputation of an arbitrator in a particular field. And so in order to check all of this, parties and the lawyers conduct thorough due diligence that consists of reviewing articles, books written on a particular topic. Now, as it seems, you can also watch webinars by particular candidates to see how they appear in public, and speak on particular topics. And finally, an important, not to be underestimated criterion is personality of the prospective arbitrator, whether he or she is hands-on, diligent, and really works on the file. Also an interesting point that is marked on the slide, cultural awareness. This is also relevant if you have an international setting, parties from all over the world. It's important that the prospective arbitrators consider cultural differences and the fact that the ways of communicating vary depending on where the participants come from. With 3-member tribunals, it's important when, in particular, when a president is nominated, it's important to make sure that the prospective president has the ability to build good relationships within the tribunal. And for all these selection criteria as well, a due diligence shall be conducted. Thank you.
So having defined an arbitrator profile based on the necessary qualifications and the ideal personality, there are further attributes that a party would look for in an arbitrator candidate, depending on the case theory and the case strategy. It's a very strategic decision. So these other criteria can be the culture, the legal culture, if someone is from more common law or from the civil law world, is whether or not that candidate would keep an open mind through the process or adhere to preconceptions, whether how the approach to an interpretation of a contract is that more a black letter lawyer, is more maybe a common law lawyer, or good faith approach, and also approaches to document production, taking of evidence, or other procedural matters. All of these should be part of the due diligence that a party is undertaking. And the selection criteria are not exactly the same if you are looking to select a co-arbitrator or a presiding arbitrator. Now, in the co-arbitrator selection, you want someone who will play his or her role in the tribunal. You want someone who is assertive, who can convince the other members of the tribunal, who possibly has some kind of predisposition towards a party's position, although this is difficult to seize and to find out, obviously. What you don't want is to appoint someone who is biased in favor of your parties or your own case, because that will eventually backfire on your own case. Experience shows that arbitrators who are overly biased or biased at all will eventually be isolated within the tribunal and probably risk that the majority of the tribunal will take a decision in the other direction. You want someone who is diligent, who will participate actively in the tribunal's decision making, and obviously someone who has a good reputation, who will be recognized as a peer. And what's interesting is if you're the claiming party and you're the first one to make a selection, you have to think ahead and you have to anticipate how your appointment will probably influence the dynamics within the tribunal. And also how your appointment, how the co-arbitrator you're going to select will, what kind of president or presiding arbitrator that co-arbitrator will select. Now, when selecting a presiding arbitrator, the criteria are different because the presiding arbitrator has the bulk of the day-to-day case administration. So you want someone who has good case management skills and experience, who can really engage, who is on top of the facts, on top of the law, who has the ability to anticipate procedural issues, a sense of fairness, and above all, also a relationship with the co-arbitrators that is equidistant. So he's not too close to the one or to the other, but who will listen and build, ideally, a consensus in the tribunal that will help make a decision at the end of the day, and not to underestimate the practicability points. You want someone who has his or her office at a location that is easy to reach, because oftentimes the location of the presiding arbitrator will also have an impact on where hearings or meetings are held. You want that arbitrator possibly to have a certain infrastructure or have a back office or enough people who can help as tribunal secretaries. Now, once you have selected someone or selected the profile for the ideal co-arbitrator or president, where do you start looking? Now, in practice, one way of starting to look, it's a good starting point, is to do a research on certain websites that exist, like the ASA website. There are a whole number of profiles, and you can do a search according to the law, the languages spoken, the nationalities. There are also some more recent developments like the GAR Arbitrator Research Tool, the Arbitrator Intelligence website, where you can start looking, and Arbitral Women for female arbitrators. But these search engines and other directories are mostly a starting point, because you want to collect intelligence about these people, and you don't get that much intelligence from their websites or from these arbitrator research tools. So almost the most important way of looking for candidates is word of mouth, is hearing from people who have first-hand experience, exchanging views, and trying to get more information through talking to colleagues, for example.
Thank you. And once you know how to identify the candidates, and once you have the ideas for candidates, how do you go about in contacting them? So there are different rules that were established in the arbitration world with respect to co-arbitrators and with respect to presiding arbitrators. So for co-arbitrators, first you would establish a short list of ideal candidates. Conduct the due diligence for the qualifications that we have just discussed. That in the first place, you would contact the candidates and ask for their availability and conflicts of interest. Some can say no right away. It is acceptable to conduct a short interview with the candidate, but it is clear that it's only should be limited to the issues of availability, independence, impartiality, experience in a particular industry, willingness to consult the appointing party when selecting the presiding arbitrator, so the whole procedure for the nomination of the presiding arbitrator. I have seen some cases where co-arbitrators, when submitting acceptance forms, would also enclose the whole transcript from the interview with the appointing party, just to show that the merits of the case were not discussed. With respect to presiding arbitrator, it would be unusual for the parties directly to contact the candidates. Usually what happens in practice is that if the co-arbitrators make the nomination, they would contact the candidates for the presiding arbitrators, but often in consultation with the parties. Institutions make appointments a little bit differently. Although I have to say that the criteria that we have discussed before, such as in particular independence, impartiality, availability, and experience in a particular domain that is relevant, are the criteria that are considered by institutions. So they will not just appoint the first person that comes to mind. But I would say that arbitral institutions will also use the insider knowledge, and that's different to the parties a little bit. Because, for instance, if an arbitrator has already done a construction arbitration and has done really well, the institution knows that it's a good idea. But on the other hand, if an arbitrator has been delayed in several cases and has been, there have been complaints from the parties, this is the insider knowledge that might prevent the arbitral institutions from considering a candidate for the appointment. Institutions, of course, will also approach differently the issue of nationality. In particular, if an institution is appointing a sole arbitrator or presiding arbitrator, if it is an international case in particular, the institution might want to try to find a more neutral nationality towards the parties. Moreover, this is still me, right, Pierre? Yes. the institution will also try to balance the competence between the members of the tribunal. So if you have co-arbitrators who are very, very experienced, you don't want to put in place a president who's inexperienced. Institutions consider as well things such as a mountain dispute, arbitration seat for reasons as well that Bernd mentioned with respect to the infrastructure. But it's important to note that many institutions have made a lot of effort in order to respect equal representation in terms of arbitral appointments. And I think many institutions have done a lot of effort in this regard to diversify appointments. So that's, I think, an important point to make. I will stop here and pass over to Pierre, maybe.
So thank you very much. So how do courts make appointments? The court will make its best to appoint a person who is independent and impartial, fully available for the case, who had the necessary experience in arbitration and in the field of the subject matter of the dispute, both on the legal and commercial or industrial sides. The court will also try to take into account the other criteria you can see on the slide, like, of course, language proficiencies, nationality amount in dispute, seat of arbitration, etc., bearing in mind that the requesting party will normally explicit in its request the relevant criteria with regard to the particularities of the case, and that the other party will, of course, will be invited to comment on these different points. And that will give to the court a clearer image of the specificities of the case and of what the parties expect from the arbitrator. Nevertheless, appointing an arbitrator is not the everyday work of a court state judge, and they do not have as much as practice in this area at the arbitration institution. And that is one of the reasons, in my opinion, why the party that enter into an arbitration agreement will usually prefer to opt for a private appointing body rather than let a court decide on this important matter. Now, if we turn to mediation, it is also very important for the parties, as Bernd explained at the beginning, to carefully select the adequate mediator to help them to settle their dispute. And we can logically address the same question as for arbitrators, as shown on this slide. And we will see that although mediation is a very different process from arbitration, we find some similarities regarding to the choice of the mediator. So who makes a nomination? The situation is here fairly the same as for arbitration, in the sense that the parties are free to agree on an institutional mediation or not, that is to stay out of the framework of an institution, and they are free to choose to resort to a particular body in case they do not agree on the mediator. Which is dissimilar to arbitration, is that there is no possibility here in Switzerland to ask a court to nominate a mediator in case the parties are not capable to do so. It can therefore be very important when the party are drafting a mediation clause to consider that situation and to provide a solution. The solution being appointing an institution or another authority to appoint the mediator. Now, if we turn to the question of whom to look for, we find once again, as maybe we can go to next slide. Thank you very much. To the same basic selection criteria as for arbitrator, that is independence, impartiality, absence of conflict of interest, of course, availability and the proficiency in the language of the mediation. The nationality can sometimes play a role depending of the subject matter of the mediation and the parties. once again, we find qualification related selection criteria, of course, a relevant experience as mediator, as well as an accreditation as mediator, some familiarity with the applicable law, experience with the subject matter or industry knowledge, everything that will help the mediator to be as adequate as possible in conducting the party and helping them actively to find the solution to the dispute, which include commercial understanding. And of course, you will conduct the due diligence, including also the reputation of the mediator. Personality-related selection criteria are very important also for a mediator. With this, we are aiming at the mediation approach of the mediator, which can be relevant for the parties. His commitment or her commitment in the file, of course, diligence and integrity, as well as cultural awareness. That will be also part of the due diligence that the parties will conduct when they try to find the adequate mediator.
And so the question is, where do you find these ideal, sorry, I'm trying to put on, these arbitrators, these mediators are available. There's several research tools that are set out on the screen, which allow you to find possible mediators, the various search engines. But as with respect to arbitrators, as a word of mouth and sort of calls to colleagues may actually be very helpful, just to make sure that that you have this personal aspect of the you get the personal aspect about each mediator. So talking to colleagues is definitely very very important. In terms of institutions, several institutions have rules for making appointments. I think it's whether there are special committees or other bodies who make the appointments. I think it's important, like with arbitration, that these rules are transparent, because the parties should know, like with arbitrators, who and how makes the appointment. As with respect to arbitrators, when appointing mediators, institutions are very strict with respect to independence, impartiality, availability, and so forth. There is, of course, the issue of insider knowledge that will be as well important. With respect to mediators, the specificities that the institutions will look for a mediator that is particularly important. And with respect to language proficiencies and so forth, some institutions may have recourse to the local representatives to look for people with more original, if I may say so, language skills. Bernd.
Thank you. So let's move to a different topic, which is the rules of the Swiss Chambers Arbitration Institution as appointing authority and case administrator in UNCITRAL, ad hoc, and other proceedings. These rules are not that well known on the market, which is why we would like to draw your attention to them and make you a bit more familiar with them. They have existed since 2014, and now in 2020, SCAI has put together a committee that has conducted a general overhaul and revision and also modernization of these rules. In particular, the scope has been broadened. It now includes not only arbitration, but also mediation and even the appointment of experts. It covers other services than the appointments. I will come to those in a minute. And there's also a more detailed provision on costs to be in line with the SCAI's practice. And I should also mention that these rules exist in 4 languages: English, German, French, and Italian. Now, in order to apply for SCAI's services to the market, you will need an agreement between the parties, or a designation by the Secretary General of the PCA, the Permanent Court of Arbitration in The Hague, or the transfer of authority by another organization or association to SCAI, such as from, and that is a recent development, the SIA, which is the Swiss Society of Engineers and Architects, is now using SCAI as an appointment authority. The same applies to the 6 exchange regulation and 2 local associations in Geneva that are listed here on the slides, and there are possibly others who will join soon. Now, what are the services provided by SCAI? Obviously, the appointment of arbitrators, mediators, and experts. Then decisions on challenges or other reasons for replacement of arbitrators, mediators, and experts. Then the assistance in fixing fees. So everything that has to do with the fees and fixing fees, evaluating, assessing fees of the arbitrators, the mediators, and the costs involved. Also administrating and managing the funds that the parties pay as a deposit in the arbitration or mediation. And that is also new. The SCAI will act as a repository of published information under the 2014 UNCITRAL rules on transparency in treaty-based investor-state arbitrations. There's also a new cost schedule at the end of these rules. Generally, the registration fee is 4,000 Swiss francs. That covers one service of SCAI, and then you have other fees for additional services or depending on the duration of these services. Thank you very much. That concludes our presentation, and we're now available for questions and answers. And I see that in the chat box, there are already a few questions.
Yes, many thanks, Bernd, Pierre, and Maria. Maybe just 2 comments from me before we turn to the questions. Well, even 3. Many thanks, first of all, for your presentations, which were very clear and also very interesting. As we can see, many of the criteria are the same, but the situations may vary. I would like to point to 2 points about how institutions make appointments. I cannot speak for other institutions, but I can certainly speak for the Swiss Chambers Arbitration Institutions because I have been the executive director thereof for more than 5 years now. What I have seen in the last years is that the neutrality of the nationality is an interesting point and is taken into consideration each time. And I know that in some countries, parties, counsel, arbitrators place a lot of weight in this qualification or circumstance, usually because in their country they have a lot of they have a different view than we have in Switzerland. In Switzerland, people cooperate a lot. In some other countries, there are many tensions between certain families, certain groups of inhabitants and citizens, political parties. And for these people in these countries, it is absolutely key that the arbitrator selected or mediator or expert is of a neutral nationality. They place a lot of weight on this. In Switzerland, we place less weight on this because our experience has shown that usually the arbitrators perfectly know their duty of independence, impartiality, and neutrality, and they do respect, and even to the contrary, when they are named and they know that they could be under scrutiny for lack of impartiality or independence, they are even stricter on their impartiality, and this may turn in the favor of some parties sometimes who would have thought that this arbitrator is going to be lacking of impartiality. We sometimes have the problem that for some small cases where the amount at stake is low and the applicable law is Swiss law, it is sometimes difficult to find an arbitrator who is in the right location, of the right nationality in terms of costs, who knows the applicable law well so that he will not take too much time to resolve the case, and who will remain impartial. So sometimes we consider a Swiss-based or a Swiss national arbitrator for a case where a party is in Switzerland and another party is not in Switzerland. If we see that the party that is not based in Switzerland is disagreeing with this procedure, usually nowadays we will refrain from using a Swiss arbitrator, but for the sake of efficiency, sometimes it's actually useful to to consider using a Swiss-based or Swiss national, even though one party is Swiss. We have never ever been blamed or had to face a claim in the Swiss Supreme Court or in another Supreme Court for this type of decision. Also, this is allowed in Swiss law. This might not be allowed in the arbitration law of every country. But this is just a point that is important for the Swiss Chambers Arbitration Institution to make. Another point, I am a woman personally, and we are today 2 women on this presentation. SCAI pays a lot of attention to diversity, not only gender diversity, but also age diversity. SCAI appoints a lot of young practitioners in order to give them a chance to learn and to gather experience. And even though we may not have reached every year 50% of gender diversity, even though we almost did 1 year, we are still a little lower than that, but that's also because of a difference in numbers between the number of men and women available. And we also don't want to repeatedly appoint the same women and refuse to appoint very good and efficient men. So we have not yet reached equality, but we are aiming at it and we are working in the right direction. Going to the questions, I have seen that there is a question that is a small one. So let's take the small one first. Marlon El Haddad asked, how can a practitioner or attorney at law working in arbitration field in his own country in his national arbitration law be selected by European corporations? Maybe that's a good question for you, Maya.
You mean somebody from not from Europe? I understand. I understand that is.
I think it's somebody who is very. I understand it to be somebody who is very locally domestic arbitrator, and who would like to be active in the international arbitration field and selected by companies based outside of his country. That's the way I understand this question.
Selected as arbitrator, I presume, or mediator. I mean, in order to be selected, you need to be known in a field. And so, one, you need to make yourself known to arbitral institutions and mediation institutions, but also be active in general, you know, speak at conferences, talk to people. You just have to be, you don't just get appointed from nowhere. So be visible well, try to publish, and then all institutions now try to diversify as much as possible appointments. So I think are interested in enlarging the pool. And I think that many European institutions do that already. So, for instance, you know, we had cases where, for a case with absolutely no link to Europe, we would consider appointing an Egyptian arbitrator. So it's already happening. Thank you.
Thank you, Maya. Bernd or Pierre, do you want to add something? Or?
Yes, I would simply add that you shouldn't be shy to reach out to institutions and send them your CV and say, you know, this is my CV. I have experience. I'd be happy to be appointed if the opportunity arises. Then at least you're on the radar screen, and maybe at some point the case comes up where the institution will say, okay, this is the profile we're looking for. As Maria said, it's all about being visible and being known. You shouldn't be shy about reaching out proactively to institutions. The other way of being appointed is obviously being mixing and mingling in the arbitration community, attending conferences and so on, just to be visible and have people get to know you.
Which is more complicated right now as everything happens online.
But we are already very fortunate to have this technical
Exactly.
opportunity that did not exist 20 years ago. We have a question from Victor Bonnen. He asked, considering that the parties will plead on the law and will indicate the legal provisions and precedents that should apply to the case and how they interpret them, do you think that it's key to have at least one member of the tribunal who knows that law? Would it be enough that at least one member knows that law and belongs to the same legal family? So my understanding of this question is, Do you always need at least one arbitrator in a panel to know the applicable law? Or do you think all of them should? Maybe Pierre, would you like to start?
Well, under the control of my colleagues, because I don't know if we are in the same line on this, but I would say that it would be more balanced if all the arbitrators have a similar knowledge and experience in the applicable law in order to be able to discuss. But of course, I'm a bit influenced by my background as a judge, where I had colleagues that have the same education and experience level as I had. So maybe we can hear something different from my colleague in terms of arbitration field, but that would be my answer.
Thank you, Maria.
Bernd, go ahead, and then I can complete if you want.
Yeah, I would say it's ideally at least one member should be trained in the law, or at least the family. But in practice, you have all sorts of mixes in tribunals. You have common law, civil law mixed. Even if it's Swiss law, you might have an English or an American arbitrator on the tribunal. That is completely common. In arbitration, the approach is quite flexible, but usually the parties would try to have at least one member of the tribunal be trained in the applicable law. But then I want to speak about an anecdote. I was once appointed as an arbitrator on a case. The other arbitrators were Scottish and Swedish, and the parties were Ukrainian and Russian. And the seat of the arbitration was in Amsterdam. The applicable law was not determined. So once we were constituted as a tribunal, I was a co-arbitrator. We had a Swedish chairman and a Scottish, the other co-arbitrator. We had to decide upon the applicable law. And so the parties argued and eventually agreed that it should be Dutch law. So neither of us, we're all civil law trained, Swedish, Scottish, and Swiss, but we were not Dutch lawyers. But both parties had Dutch counsel who would argue the law, and we would apply Dutch law. And when we were unsure, we would go back to the parties and ask them to explain. So it's this can also happen. You don't always have an arbitrator who's trained in that law on the tribunal, but ideally there should be one, is my view.
And I would agree with that. And I would say that in an international setting, very often you only have one arbitrator. If you have a 3-member tribunal, usually you only have one member of the tribunal who actually is knowledgeable in the law that is the subject that is applied in the particular case. And the parties will plead the law to them. But you may also have cases in international arbitration where, for instance, Polish law applies, and the one party is Polish, the other party is not Polish, and then you cannot appoint a Polish sole arbitrator if there's one arbitrator, and then you end up having a sole arbitrator who's not knowledgeable in Polish law. And then I think it's sufficient to just choose somebody from the same legal family, as Victor says. So, because I think we are all sufficiently experienced to apply other laws, but I think it's a fair point to refer to legal family. So for my Polish case, probably better to get a Swiss arbitrator than an English one. Or a Spanish, or just go for Victor.
That reminds me of a mediation case where I was sent to Australia, and you can imagine the jet lag that it means, especially since I was just returning from Colombia. And I was there, and the other party was also accompanied by a CFO that came from Aberdeen, from Scotland, and all the other persons there were Australian, and the case was Australian with Australian law applicable. And it was a mediation though, so the law was less of importance. But the 2 persons who ended up negotiating and solving the dispute were this Scottish CFO and myself, both completely jet lagged and holding our hands like this because we were so tired. And actually, what is important, and I think it's very important to remember, everyone who is on this call today, that arbitration and mediation is about resolving commercial disputes. Resolving. So the law is important. Yes, especially in arbitration, less in mediation, but still to a certain extent. But what is important is also to have a sound understanding of the commercial issues and of having a good will to resolve the dispute. I think that it's very, very important that arbitrators remember that arbitration was created to solve disputes between traders, business people, and they care less actually about the applicable law than do the lawyers. So as long as you remain within certain lines, there is a playground that is a little bit broader, in my opinion. Maybe Pierre disagrees as a former judge, but in arbitration and in mediation, you should have a broader range of opportunities to solve a dispute than as strictly applied by a local judge. But don't know if you
I agree. I don't disagree.
Thank you, Pierre. Taking another question that is quite interesting, we have a question from somebody also from Lausanne, Pierre, one of your neighbors, maybe Philippe Boss. He's talking about the very recent Swiss Federal Tribunal decision in the Sun Yang case. I don't know if you are familiar with it. The Swiss Federal Tribunal stressed that the parties' had a curiosity duty prior to nominating an arbitrator. The tribunal said and gave some guidance as to the due diligence that is to be conducted, for example, in social media postings, but they acknowledged as well that this can be very wide. The question that is asked by Philippe Boss is the following: to what extent do you consider that arbitrators shall also collaborate to this curiosity duty and, for example, share social media accounts, for example?
I'm happy to have a first go at the answer. So I think first and foremost, it's the each arbitrator's duty to make sure that he or she discloses all elements and facts and circumstances that could put into question their independence and impartiality. And that may imply disclosing things that have happened on social media, things that they have posted and said. This is primarily their duty. Obviously, we talked a lot in our presentation about the due diligence that is conducted by the parties. And some parties may be less experienced, and some may simply do due diligence and not see this in social media, or they don't have access to the social media. But I think there's the duty is primarily on the arbitrators, but the parties should do their bit if they're interested in having integrity in the proceedings. Obviously, this can be a strategy to derail or obstruct the proceeding, is to not to appoint someone where you know very well that there might be an issue, and then later on you use that as a pretext to challenge that very arbitrator that you have appointed or something similar. So there may be obviously strategic guerrilla tactics where you could use this, but otherwise, if both the parties and the tribunal members are interested in safeguarding the integrity of the proceedings, they should disclose and also go and look for these circumstances.
And that reminds me of some challenges that I have seen some years ago. There were some challenges that were discussed at the SEC, Facebook challenges, for instance, that a party would try to challenge an arbitrator just because he was connected, or how do you call it, on Facebook with one of the counsel of that they're friends, and this has not been successful. But I think, as Bernd said, transparency. So if a party has questions, arbitrators should just ask, but I don't think it should go too far. Probably this social media due diligence.
Also with artificial intelligence, I think now already, or in a few years' time, as an arbitrator, you cannot hide behind firewalls and all these things. Things will eventually be known and be taken into consideration in evaluating, assessing somebody's independence and impartiality.
Thank you, Pierre. Would you like to add something, or?
Well, I think in that decision, the Federal Tribunal tried to draw a line between what the parties have to find out during the due diligence and what they could legitimately say that they have known after the award. And the parties in that decision was on the safe side, because the federal tribunal did say that the appellant party did not have to know what was on the Twitter account of the arbitrator. So, of course, there is a duty to do some due diligence, but in that particular case, the federal tribunal did not say that the party had to know what was in the Twitter account. So I don't think it's a too scary decision for practitioner, but I don't know how maybe Bernd or have read it, if the practitioner find that it's a decision that pushes the limit of the due diligence. I'm not sure about that.
Well, when we conduct due diligence for clients, we do look at publications. We look at if these people have spoken about certain subjects. Usually they have listed their speeches and their publications on their websites. Now, what we haven't done in the past is go and look on social media if somebody has tweeted something or not. Maybe this is something we'll have to do in the future. I have to think about that. In that way, it's not troubling, but it may create additional costs and efforts that you have to undertake in order to do a full and thorough due diligence.
But on the other hand, I mean, the Twitter is but we should not, for instance, I think, look too much into things like Facebook, which is personal. And I think we should draw a line between professional life and personal life. So if a prospective arbitrator likes to post photos of him with, fishing or I don't know, whatever, that's personal life. So I think we should draw a line in terms of social media as well.
Thank you. I agree. And also what is important to remember, and this case concerns a party that was in China, if I remember only the summary, unfortunately, I read about it. When I was in China, I did not have access to LinkedIn and to Google and to many other applications. On the contrary, they use other applications like WeChat that I did not have access to myself as a European, because it's all in Chinese. So to what extent can we have a due diligence with a Chinese person? It might be limited, and then it goes, I don't know, there is no limit at the end. Do you want to send a detective to make a complete scrutiny over everybody? I mean, we have to draw a line at some point as well. I agree with Maria and Bernd and Pierre on this.
An appointment is an act of confidence, and I think we should all assume that there is a certain confidence between all participants as well, that you don't have to check it too much.
Thank you. I see we don't have any question left. We have many thanks from Philipp Haberbeck, so many thanks to him for thanking us for a very good presentation. Actually, not us, but especially Maria, Bernd, and Pierre. And I give you each one after the other one the last word if you want to say something, if you think that something could be added. Maybe Maria?
Well, thank you very much. Well, stay safe, everybody. And I hope that next time at the SCAI event, I will be able to meet you all in person. Thank you very much.
Bernd?
Yes, thank you very much for attending this webinar. It was a pleasure to present you, and don't hesitate to reach out if you have any questions remaining.
Thank you, Bernd. Yeah?
And my turn to thank you all for watching us, and stay safe.
Thank you. Thank you to all. And for those participants who may have joined later or who want to re-see the slides and hear our presenters, we will post this webinar on YouTube and on our website in the coming days, and we will announce it on LinkedIn. So feel free to follow our website, follow us, and reread this webinar, and also to join our next conferences and webinar. Our next conference is also a webinar, but it's a real and longer conference. It's the Innovation Conference, and it will take place next week on Thursday, the whole day, or no, sorry, we shortened it, the half day, the afternoon. And it will be about disruption in arbitration, and there may be some presenters will speak about how to challenge an arbitrator in the middle of the proceedings to create some major disruption. But many thanks today for our presenters and to all participants. We look forward to seeing you again, first of all, live in our events and also in our webinars until we have the opportunity to meet live. Thank you to everybody and bye-bye.
Thank you. Bye.
Bye-bye.